Human rights. The term human rights is used to refer to a wide spectrum of rights necessary for a human to live a life with dignity. The primary element recurring throughout each of these definitions is universality. Human rights are commonly understood as the inherent fundamental rights to which a person is entitled simply because he or she is a human being. Alam naman po natin na kapag sinabing human rights is mga karapatang pantao. We have freedom of speech, freedom of beliefs, freedom of religion, freedom of education, at kung ano na pang freedom. Kung saan, walang sino man ang makakapigil sa atin pumili kung ano ang ating gusto, kasi karapatan naman natin to bilang tao. At may mga batas ding sinulong upang mapanatili ang kapayapaan sa pagitan ng mga karapatan. Pero ang mga karapatang ito ay may kaakibat din na obligasyon dahil alam naman natin na yung iba, porque sinabing karapatan is inaabuso na nila. Kaya kailangan na maging bukas ang ating pag-iisip para maging tama ang paggamit sa mga karapatan. Natural rights are owned by all human beings that are derived from nature. Human rights are considered the offspring of natural rights, which themselves evolved from the concept of natural law. Eventually, this concept of natural law developed into the natural rights. This change reflected the shift in emphasis from society to the individual. Natural rights refer to the rights given to all humans, simply for the sake of being human. They are universal moral principle among all cultures and society and can't be reversed by the government law. Natural rights are often called inalienable rights, rights that cannot be taken away. They would exist even if the government didn't exist. Example dito is yung right to make a living and right to have a family. Walang batas na pinatupad kapag gusto mong magkapamilya as long as kaya mong bumuhay ng isang pamilya, pwede kang magkaroon ng pamilya. The civil rights are derived from membership in society formed out of a social contract and are thus distinct from the natural rights. Under this conception, civil rights can be changed because it is derived from society rather than God or nature. They depend on a specific level of social organization and wealth and hence cannot be claimed by the member of the society as a legacy. Civil rights guarantees the equal social opportunities and equal protection under the law. Example po dito is freedom to vote, freedom to express oneself, and freedom to remain silent in a police interrogation. Siyempre, bilang isang mamamayan, karapatan natin bumoto kung sino ang sa tingin natin na may maitulong sa ating bayan o bansa. At sa freedom to express oneself naman is may kalayaan tayo na sabihin kung ano ang ating opinion at kung ano ang sa tingin nating tama. Generations of human rights. There are three overarching kinds of human rights norms. First is civil political rights, are a class of rights that protect individual freedom from infringement by governments, social organizations, and private individuals, and which ensure one's ability to participate in a civil and political life in the society and state without discrimination or repression. They have two kinds of civil political rights. First is physical and civil security. Example dito is no cruelty, slavery, inhumane treatment, arbitrary arrest, equal before the law. And second is civil political choices or empowerments. Example is freedom of thoughts, conscience, and religion, freedom of assembly and voluntary association, political participation in one's society. Socioeconomic rights provide protection for the dignity, freedom, and well-being of individuals. They also have two kinds. First is provision of goods satisfying social needs. Example dito is food, shelter, healthcare, and education. Next is provision of goods satisfying economic needs. Example dito is work and fair wage and adequate living standard and social security net. Cultural or collective developmental rights are commonly perceived as the most neglected or least developed category of human rights. They also have two kinds. First is the self-development of communities. Example dito is their political status and their economic, social, and cultural development. Second is right of ethnic and religious minorities. Example dito is to their enjoyment of their own cultures, language, and religions.
Labor rights as human rights. The right to work has been spearheaded by the International Labor Organization, or the ILO, since its creation in 1919. Work provides an element of human dignity as well as it provides the remuneration important for securing an adequate standard of living. Labor rights are relatively new addition to the modern corpus of human rights. So human rights may be viewed as foundation of the law, and sometimes worker rights are considered the human right, whether it is a labor foundation or something else. Human rights has become increasingly important and pervasive for a number of reasons. First is, human rights have dominant status and political impacts on both the authority and community. Human rights claim that therefore be used by civil society organizations, labor law movements, and even business organizations to gain public support for their activities that trust the government also to adopt. It claims, based on the human rights discourse, mean that labor movements can move away from economic arguments and special interest and toward a position based on ethics and morality, which transcends any controversy over the impact of union on the economy. Second, human rights have significant normative power. Subsequently, that claims that relate to human rights are often strong enough to win most of the time when they compete with other considerations. Labor rights, which gains this status, are not easily denied. An excellent example of this is the current status of an anti-discrimination law, which is increasingly based on the notion that discrimination in work environment is a breach of human rights. Looking at the HR, which is the non-binding but enormously influential document, CIVL 2010 claimed that the several human rights are labor rights. We have Article 4 of UDHR prohibits slavery and servitude. It is the right to work, the right to choose freely the type of work, and the right to claim fair wages. And also Article 23 that confirms everyone has the right to work in a job freely chosen, the right to receive equal pay, the right to get decent compensation for work performed, which should guarantee a dignified life for himself and his family, the right to work in a healthful environment, and the right to form and join trade unions. And also we have Article 24 that guarantees the right to rest and leisure, including reasonable limitation of working hours as well as the holidays with pay. The following are the International Covenant of Economic, Social, and Cultural Rights that are described as follows. Article 6 that confirms everyone has the right to recognition everywhere. Article 7 that guarantees equality for all without any discrimination, and Article 8 that gives everyone the right to an effective solution by the competent national courts for acts violating the fundamental rights granted by the Constitution or by law. In recent years, the ILO endorsed the list of labor rights as human rights. In 1998, it adopted the Declaration of Core Labor Standards. The declaration binds all ILO member states, irrespective of whether they have ratified and relevant conventions, and states the 5 core rights. Number 1, the prohibition of all forms of forced labor. According to Article 4, prohibition of slavery and forced labor, no one shall be held in slavery or servitude. Thus, no one shall be required to perform or forced or compulsory labor. Number 2, the abolition of child labor. Ensuring that every girl and boy has the opportunity to develop physically and mentally to his or her potential. It aims to stop all work by children that jeopardizes their education and development. Number 3, the elimination of discrimination in employment. Number 4, freedom of association. That is one of the most basic rights enjoyed by humans. It ensures that every individual is free to organize and to form and participate in groups either formally or informally. And lastly, the right to collective bargaining. It is the right of individual employees in a workplace to come together and to choose a representative based on a majority vote, who will then negotiate with their employer over terms and conditions of employment. The individual worker typically lacks meaningful bargaining power to negotiate favorable employment terms. Designating a representative to negotiate on behalf of the large group of workers can level the playing field between labor and management and give the workers a meaningful seat at the bargaining table.
Developing a human rights policy. So why do we develop a human rights policy? First is to provide the basis for embedding the responsibility to respect human rights through all business function. Such a policy is the first step in showing that the company understands its universal responsibility to respect human rights. It provides the basis for publicly affirming company's values and embedding the responsibility into company's operation in the way it does business. Next is the response to relevant stakeholders' expectation. Having a human rights policy is explicitly required by the framework and the guiding principles and increasing expected by relevant stakeholders including investors, business partners, and governments. Next is to identify the policy gaps and initiate a process that alerts the company to new areas of human rights risk. Next is to elaborate on the company's commitment to support human rights. Next is to build increased trust with external stakeholders to start to understand and address their concern. And to foster the development of the in-house learning management capacity in leadership on human rights issues. Lastly is to demonstrate international good business practices. So, according to United Nations Global Compact 2015, organization adopt human rights policy for 3 reasons. First one is a universal responsibility. Business have responsibility to consider international human rights standards regardless of whether they are operating in an area of weak governance of obligation or domestic regulation that do not comply with international human rights or in a more stable context. Second is the commercial purposes. Demonstrating respect for ethical issues such as human rights and social responsibility is increasingly becoming a common international business practice in order to provide business good intention. Such intention or practice serves the organization to achieve its commercial purpose as the following. First is to gain a competitive advantage. Many organizations believe that showing respect for ethical concerns such as human rights and social responsibility gives them a competitive advantage over competitors that look over the area. Next is to build the trust with stakeholders and address their concerns. Good practices, especially in the fields of human rights and environmental issues, enhance the stakeholders' trust in the organization's business. Many organizations also find that external stakeholders become more willing to engage constructively with them when they have such policies and approach in place. Next is the legal concern. The responsibility to expect human rights is not a legal duty imposed on organization by treaty, but it is not a law-free zone either. The provision of many international human rights treaties are embedded in most countries' law and many governments have adopted the Rome Statute of the International Criminal Court, which is depending on the provision of their own criminal code. It may mean that they are empowered to prosecute companies for certain international human rights violations.
Let's move forward to key labor right related articles. So hindi ko na babasahin yung nasa PowerPoint. I will explain it directly. So yung labor and employment laws, sila yung nagbibigay ng mga guidelines sa isang workplace. At dito natutukoy kung ano ang responsable ng mga empleyado at employer. So these laws are crucial because they enable business to devote more their focus to productivity and profitability rather than giving constant energy and resources to problem solving. So meron ditong some significant articles related to labor rights. First is child labor. So dito sa child labor, ang mga batang wala pang 18 years old ay hindi pinapayagan na magtrabaho sa mga operasyon o trabaho na nangailangan ng labis na pagsisikap or mga activities na maaaring mapanganib sa kanilang kalusugan o kaligtasan. Pero dito sa atin sa Pilipinas, merong 2.1 million na mga child laborers na edad 5 to 17 ang child laborers dahil nga marami sa atin ang may hirap. Kaya ito ang nagiging dahilan sa atin. Maraming mga pamilya ang nahihirapan at tumaharap sa malaking pagsubok at mahirap na desisyon pagdating sa pagpapadala ng kanilang mga anak para magtrabaho. Kaya hindi rin natin napipigilan yung pagdami ng child laborers dito sa ating bansa. Kasunod naman ay ang fair wages or compensation. So dito, ang mga may-ari ng negosyo ay dapat magbayad ng kahit man lang na minimum na sahod o naangkop na umiiral na sahod. Alin man ang mas mataas. At saka they need to comply with all legal requirements on financial aspects. Dapat rin na mabigay nila yung anumang mga benepisyo sa lahat na required ng batas o kontrata. If the compensation paid does not satisfy the worker's basic needs and provide some discretionary income, the business partners are required to take appropriate actions that seek to progressively realize a level of compensation that does. Next is forced or bonded labor. So ang forced labor, ito ay nangyayari kapag ang isang individual ay napilitang magtrabaho or magbigay ng serbisyo sa pamamagitan ng paggamit ng puwersa o dahas. Ang mga may-ari ng negosyo ay hindi dapat gumamit ng sapilitang paggawa. Walang empleyado ang maaaring mapilitang magtrabaho sa pamamagitan ng puwersa o pananakot sa anumang paraan, or bilang isang paraan ng political oppression o bilang parusa sa paghawak o pagpapahayag ng mga pananaw sa politika. Next is health and safety. So dito, walang sinuman ang dapat na nasa peligro or panganib dahil sa kanilang trabaho. Lahat ng tao ay may karapatang umuwi sa parehong estado mula sa kanilang pagpasok hanggang sa pag-uwi. Sabi nga dito, members of the public are also entitled to expect. Yun, to make sure nga na ang mga activities sa trabaho ay hindi makakasama sa kanila. Ang mga employer ay dapat na nakatuon upang mabawasan ang panganib at panatilihing malusog ang kanilang mga empleyado. Sabi nga sa Republic Act 11058 or an act strengthening compliance with occupational safety and health standards and providing penalties for violations thereof, employers are now required to comply with occupational safety and health standards, including informing workers on all types of hazards in the workplace and having the right to refuse unsafe work, as well as providing facilities and personal protective equipment for the workers, among others. Next is discrimination. So dito, ang mga may-ari or managers ay dapat respeto o igalang ang mga karapatang pantao ng bawat individual at huwag makilala ang batayan ng lahi, kulay, relihiyon, paniniwala, kasarian, edad, katayuan sa lipunan, pinagmulan ng pamilya, kapansanan sa pisikal o mental, o oryentasyong sexual o gumawa ng iba pang mga paglabag sa mga karapatang pantao. Yung mga ganong diskriminasyon ay hindi pinahihintulutan kasi nga hindi tama. Dapat umayon tayo sa tama. Kung alam nating may naiiba sa isang tao, dapat di na natin pansinin or laitin. Kasi sino naman tayo para mang-discriminate ng isang tao, di rin naman tayo perfecto, di ba? So itong mga may-ari o managers, dapat din silang maging matatag sa pagsuporta sa karapatang pantao sa lahat ng kanilang mga ginagawa. Ang kamangmangan at hindi pagkilos ng isang tao ay hindi dahilan para sa isang diskriminasyon. Lastly is working conditions. So dito, dapat hawakan ng mga employer ang lahat ng mga empleyado ng patas at matapat regardless kung saan sila nagtatrabaho. Dapat wala silang pinipili ng mga empleyado at wala silang favoritism. So ang lahat ng tauhan ay dapat may nakasulat na kontrata ng trabaho na may mga napagkasundo ang tuntunin at kondisyon, including the notice periods on both sides. And all personnel are allowed to reasonable rest breaks, access to toilets, rest facilities, and potable water at their place of work, and holiday leave in accordance with the legislation of the country where they work. And all employees must be provided with appropriate job skills training course.
Labor rights in tourism. Labor rights are entitlements that relate specifically to the role of being a worker. Some of these rights are exercised individually and others collectively. Employer rights and employer awareness of areas of conflict and sensitivity are some of the significant issues in tourism industry. The labor issues in tourism industry are upon four areas. Number one is the hiring. Number two is the investigation of employee misconduct. Number three is firing. And number four is the post-recruiting decisions by management. Since tourism is one of the largest industries in the world, the magnitude of the impacts of human rights violations upon its employees cannot be whiled away. Social justice is not only about a set of abstract legal rights which had little to do with the experience of general society, but it means that the law could expand to meet social inequality and was not constrained by the liberal commitment and non-intervention. This gave a space for the development of labor law to meet the social compromise of the early 20th century. New legal forms came to the fore which recognized the interdependent activities of the stakeholders and a need to coordinate those activities in the public interest. However, the relationship between human rights and social justice nowadays is not straightforward. This may be because social justice has been considered as outdated, and increasingly there are arguments that human rights are calling the same claims of social justice. Number two, some activists and labor unions representatives of the second generation view social rights as opposed to civil and political rights. Many labor rights, if they can be viewed human rights at all, sit for better with the economic and social rights. For example, it could be argued with that minimum wage legislation was more in common with the character of a social rather than a civil or political right. Despite this conflict, the importance of social justice was identified in ILO Constitution, and also the labor standards creation was spotted as the significant tool in achieving and settling the social justice. The seven policies concerned in the Constitution discerned three priorities in the ILO terms of social justice. Number one, work as a source of livelihood and fulfillment. Number two, prevention and exploitation. And number three, workers' protection against the difficulties of working in dangerous and inadequate environment.